The roots of Nevada County's Assisted Outpatient Treatment program stem from a tragic shooting that occurred in the county in 2001.
An individual with an untreated mental illness entered the county mental health clinic and shot and killed two individuals, then proceeded to go to a business in Grass Valley, shot and killed another individual. Several people were wounded. One of the individuals that was killed was Laura Wilcox. Laura's parents took it upon themselves to advocate and work with state legislators to enact what was known as Laura's Law in the state of California.
Laura's Law became part of California's Welfare and Institutions Code, replicating what was done in dozens of other states. Several years later, California's Mental Health Services Act provided a potential funding source for Nevada County to implement assisted outpatient treatment.
So in May 2008, after about a year and a half of planning efforts, Nevada County became the first county in California and so far, to this date, the only county that has fully implemented assisted outpatient treatment.
The program offers a unique solution that bridges the gap for dangerous people in need of mental health services who may not be on probation, are not gravely disabled, or don't meet the criteria for emergency involuntary hospitalization.
Assisted outpatient treatment allows a judge to order those individuals to receive outpatient treatment in their community. They can still live at home, they can still work, they can still go to school, but they're ordered into treatment.
The program is successful because of its collaborative nature.
The collaborative courts are amazing. It is a conversation with the judge and the attorneys and the treatment team and the individual.
And the personal contact of having a collaborative team avoids a lot of misunderstanding and allows for the benefits to proceed.
And so when you watch the judge interact with the candidate, the client, you see how there is the ability to really address some of the treatment issues with the client.
Collaborative processes have a much greater impact and are much more effective.
It's serious in that the judge attempts to hold the person accountable for that treatment plan that they agreed to, and also hold the provider accountable for saying what they're going to do to assist this person with some of the things that they feel are obstacles for them in their lives. So we are having a conversation, and it is a very supportive, recovery-oriented environment that takes place right in the courtroom.
Of 25 people referred to the program, only 5 had to face court orders to undergo treatment, and the rest volunteered to be treated. And data show that the program has saved more than $500,000 over 2.5 years.
The cost savings is related to some of the benefit to the community. We have those 25 people are spending less time in jail. That means less time for judges, less time for probation officers, less arrests that the sheriffs and local police departments have to do. So it frees up law enforcement to pay attention to other areas. Many of these individuals are now living independently rather than either homeless or in a transient lifestyle. Many of these individuals are either full-time employed or part-time employed compared to no employment before they entered into treatment. I believe that our community is safer because these folks are now in treatment versus being somewhere in the community out of treatment.